Hey, let's go to work. First in line this Saturday morning is Don from Lake County. Don, you're on News Talk WDBO. Go ahead.
Thank you so much for taking my call.
You're welcome.
I have a question about a Michigan process of dispersing a will. My wife is in receipt of a check from a will from my father-in-law's second wife, who died about 20 years after he did. The estate was worth probably somewhere in the area of about $1 million. After my father-in-law passed away, she teamed up with a financial advisor in Michigan.
All right.
The financial advisor was the beneficiary, ended up being the beneficiary of most of the estate.
Oh, boy. That doesn't sound fair, does it?
Well, you know, they were acquaintances. Both my father-in-law and the second wife were acquaintances of them 5 years before he passed away. So I know they had a relationship.
Well, just out of curiosity, did your mother-in-law, your wife's mother, did she have any other children other than your wife?
That was the second wife. This was not my wife's mother.
Okay, I'm sorry. Did the second wife have any children?
No.
So all right, so what's your question to me?
Well, the question is that we know that what the will stated flatly, that the father's children were not her children.
Okay.
But she left a small pittance to them. And
all right.
To me, it was just like, go away.
Gotcha.
All right. And also in the will, it said if they protest in any way, that they were going to be excluded from the distribution.
All right.
Okay. We know what the will said. The attorney, she's already been to an attorney, and they said that you can't do anything about that.
All right. What can I do for you?
Would there be, we suspect, maybe some inappropriate advice from the financial advisor? Is there a possibility that we could possibly seek to see if there was possibly going that route?
Don, you're confusing the issues now, okay? So, first of all, this financial advisor clearly gave second wife financial advice, and he might have, in fact, lost money for her, but at the end of the day, that doesn't affect your wife because all the money went to the financial advisor. What you might really be asking me was second wife under some kind of undue influence by this financial advisor to the degree that it would cause her to go to a lawyer and cause her to write a will leaving everything to the financial advisor? And that is certainly a possibility. Well, when people call me and they say, Tom, I want to challenge the will, my first question is this: who prepared it? If a lawyer prepared it and a lawyer witnessed and notarized it, it's probably rock solid, because when they witness and notarize a document, they're making a statement that whoever's signing it is competent and they're not under duress. Nobody's got a gun to their head. If they say, Tom, the person who inherited the money prepared the will and that person's friends witnessed and notarized the document, well, then it's automatically suspect. So, Don, I think that you guys have gotten some advice. You would have a long, hard road to get anywhere with some very uncertain results. You've talked to me for just a few minutes. You guys have talked to a Michigan attorney in more detail. If he's telling you there's nothing there, then I'm confirming that what he's telling you is probably correct.